Good morning. My name is Antonie Goosen, and I'll be the host of the iAgents Advantage. Today, I am joined by two seasoned attorneys, Tanja Nolten and Slabbert, both directors of Dykes van Heerden. Louis, we've known each other probably for 20 years, eh?
A long time, Antonie, a long time.
Seasoned attorney. This morning, we've got an incredible subject that we will be tackling, one that property practitioners deal with on a daily basis, and that is the mandatory disclosure form. Louis, maybe we can start with you. If you can just explain to us a little bit of, how the mandatory disclosure form came about and how does it form part of South African property law at the moment?
Thank you very much, Antonie, and thanks for the opportunity. Yeah, so I think the mandatory disclosure form originated formally and was legalized because of the many court cases surrounding latent and patent defects. I don't know if you recall, in the old days, the Institute also had a sort of a prescribed property condition report, but that wasn't mandatory to attach it to your offer to purchase. And obviously, through the legislation and the Property Practitioners Act, together with the regulations, they formed this prescribed form. That was actually to limit the amount of legal actions and law cases that arose because of the latent and patent defects not properly disclosed by sellers, and obviously also implicating the real estate agent. So, yeah.
So just for the listeners out there, this forms part of the Property Practitioners Act, correct?
Absolutely. Specifically, the property condition report, the mandatory disclosure form, is regulated by Section 67 and Regulations 36 of the Property Practitioners Act.
So it's prescribed, it must be in a certain form, it must address certain questions, and it's a requirement that if you market a property as a property practitioner in South Africa, that form must be fully completed and signed by any seller or landlord before you accept the mandate.
Antonie, absolutely. The Act is quite clear, and it states with subsection 1, it states, Section 67, subsection 1, that it has to be signed by both the buyer and the seller. It has to be completed properly by the seller, and it has to be attached. And that's the very first start of Section 67.
Okay.
So just interpreting that basically sums up what an estate agent should do in terms of this Act.
Okay. Once the form is completed, on that note, what other obligations rest on property practitioners with regards to disclosure of the information contained in the form? How do they go about, utilizing this form as they market and sell properties?
Okay, I'd like to give this example. So the other day, I was actually invited by two estate agents, and they asked me to accompany them to go to a seller where they actually do a formal presentation, and they were punting to get a joint mandate on the specific property. And as you know, in terms of this Act, it says that the estate agent needs to get a fully completed and signed mandatory disclosure form by the seller. And I was actually listening to these agents as they were busy presenting this property condition report, the mandatory disclosure form. And interestingly, I actually briefed them beforehand. I said, listen, I'm going to send you 2 articles, news flashes that you should read. And the ones that we drafted in terms of the footstewards clause, that actually how they explained to the seller, because you must understand where this comes from. This mandatory disclosure form is actually born from footstewards, and how they explain to these sellers what's the dynamics behind footstewards clause? What is a latent defect? What is a patent defect? And after explaining that and the dynamics behind the footstewards clause, it was much easier for the seller to fully complete, and understanding the implications of not being honest, of not disclosing latent or patent defects. So that's my advice. It's we as real estate professionals, real estate agents, we have to educate the public, and we can only do that if we know what we're talking about.
Yeah.
That's why it's not only interpreting the property condition report, but also what's behind the property condition report. And that's where the foot stewards clause comes in, because that's what the property condition report is eventually all about, declaring all the defects.
Absolutely. So on that point, to just further the discussion, this doesn't negate the foot stewards clause in any way, shape, or form. It's important, I think, for the sellers out there to know that this is not them providing a guarantee to the potential purchaser. This is them declaring all the known defects that they are aware of. They would still be not liable for latent defects that they are not aware of. Is that correct?
Absolutely 100% correct there, Antonie. I think the rationale behind the property condition report is actually leading the seller by showing him what types of defects there could be and highlight it. But for sure, there's no ways that the current property condition report can identify all the defects. That onus still rests on the seller. That's why you'll also see. I don't want to jump the gun here, but I've seen other real estate companies that's got their own property condition report. Now, obviously, now you will question me, but it has to you have to use the same format. But there is, in terms of Section 4 of the PPA, that you can apply. I think it's you have to apply for exemption. You have to fill in a Form 1E where you can apply, and then it rests before a committee, and they decide if they will accept your own property condition report. And I see that's a tendency nowadays that. And we're going to discuss, I think you're going to discuss some of the gray areas when it comes to the property condition report, why you get certain real estate companies that say this and they're going to use their own property condition report, or add a lot of additional latent and patent defects in your OTP. And that's what the regulations actually advise, not to tamper or with this mandatory disclosure form, but deal with it in your offer to purchase.
Yeah. So to be clear, you have to use the prescribed form unless you've got the exemption and your other form was accepted by the PPRA, or you deal with it separately, or in a different area of the agreement.
Also, no, you're 100% right, Antonie. I also see some agents, what they do is they just to comply with the formalities of the PPRA, that's Section 67 of Regulation 36, they do attach the property condition report, they get it signed, and they get it filled in, and then they attach another one.
Yeah.
So they fully comply with the legislation, but they add an additional one.
Yeah.
So that does not put them at risk at all. So they comply with the regulation.
That makes sense. I want to now talk about the potential repercussions if a property practitioner accepts a mandate and starts marketing a property for sale or to let without having either the completed mandatory disclosure form in place, or if that form is not attached to the agreement of sale or the lease agreement and not signed by the buyer or the tenant. What potential repercussions can a property practitioner end up facing if that happens?
So I like to quote the law. Subsection 3 and 4 deals with that. The Act refers to buyers and sellers as consumers, general public / consumers, and they can actually take action, legal action, against the practitioner, property practitioner, in terms of subsection 3, if they do not conform with those formalities. That's the one thing. And the other thing is that the Act also specifically states that if it's either not signed or attached or completed, the property is sold as if there were no defects.
Sure.
And now you can understand the repercussions on that. If you sell a property with no defects, there is no such property. I think you would agree with me, even with the new property. So yeah, you expose yourself as a real estate practitioner if you do not comply. Attach it, sign it, and complete it.
So you could be held liable by the consumer for potential defects on the property. That's the bottom line.
Absolutely.
It's supposed to be.
And interestingly enough, Antonie, you will also, if you read the act carefully, it refers not specifically as necessarily the buyer and the seller. In some instances, yes, but most of the time it refers to the buyer and the seller as a consumer. So irrespective of the PPA and the PPRA, we've got a different act coming into play, and that's the CPA, the Consumer Protection Act. Because, I mean, you can argue, like a court case that we're busy with now, is that you as the estate agent is seen in a way as a supplier of goods because you're selling property in your ordinary course of business. To whom? To a buyer, which makes the buyer a consumer. And that's why they brought in the CPA as well. And it could be applicable. So you got to be very careful as a real estate professional. You are guided by the PPA. You've got to comply with all the rules and regulations and legislation. And in terms of the CPA, you've got to be very careful that you act in the best interest of your buyer as well, in terms of the CPA.
So on that note, Tanja, how do you think property practitioners should handle the situation where a seller just says that they're not going to sign this form?
So, Antonie, firstly, I just want to say thank you so much for giving us the opportunity to be here today. I think my gut is telling us to hold the gun against their head, but we all know we can't do that, right? So I think the correct way to deal with that is just to, once again, reiterate what Louis said by educating our clients and just explaining to them that not only in terms of legislation, but practically as well, you as the agent have surely got a duty to ask the right questions. And this document is there to protect you in proving that you've asked the correct questions. And Mr. and Mrs. Seller, this is also assisting you by confirming that you've disclosed this information. So from a practical side, I think if we can educate our clients, it could be helping us in that regard.
So who should be completing and signing this form? Is it the seller alone, or is it the seller together with a property practitioner?
So my practical advice once again would be that property practitioners tries as far as they can, because we all know it's not always possible to sit with your clients and face-to-face maybe go through the document and discuss each point with them. But if that's not the case, it does happen in practice that we unfortunately sit with situations where our clients aren't necessarily always in town or in the city that we working, and that we have to maybe have a telephone conversation with them, or maybe even just elaborate and educate them via means of an email. But my practical advice, once again, would always be for the property practitioner to not complete that document, but rather have the client complete it themselves. And that is to keep the risk away from them.
That makes absolute sense.
Can I just add from a legal side again, in terms of subsection 2 of section 67, the property condition report should be signed by all relevant parties. So not completed by all relevant parties, you rightfully said that. So completed by the seller, but signed by all relevant parties. Now, my question to you, Antonie, would you reckon a real estate agent be a relevant party to that property condition report?
Well, the prescribed form makes provision for the property practitioner to all put down their signatures.
Exactly. 100% correct. So in terms of the prescribed form, it leads you as a estate agent to co-sign it, and in terms of subsection 2.
Absolutely. Another situation that we get from time to time is people that don't live in the property. Maybe they live overseas and it's an investment property, or it's a property that they bought with the idea to rent out, and they've rented it out for a couple of years, and they're not familiar with the condition of the property themselves. And then we also often, get involved in things like repossessed properties or deceased estates, where there may be an executor that's appointed to sell the property, and sometimes they are hesitant to complete these forms. What is your advice?
Tanya is good with this one. You've got this one. Absolutely.
So firstly, I would start to educate my seller, especially where the seller did not stay in the property for quite some time. If we look back at lockdown, that was maybe a good example of clients that maybe for certain long periods did not visit their own properties, whether it's a second property, maybe a investment property or a beach house or family home that they don't necessarily visit regularly, and as I say, for longer periods specifically. In that instance, I would ask and educate the seller to complete the document as far as possible. And then in that bottom little lines at the end, maybe just disclose the fact that the seller was unable to fully complete this document due to the fact that they did not stay in the property. And therefore, I would further suggest that wording gets added to say that the purchaser has had an opportunity and has made sure that he fully understands and has done the research on the condition of the property, familiarized himself with the property was the word I was looking for there. And very, very importantly, after that, I would add that the purchaser therefore indemnifies not only the property practitioner or the state agency, but also the seller. Now, going into the further detail on the other suggestions or the other examples that you made, Antonie, when it comes to owners renting out property, for example, I need you as the property practitioner to educate the seller by explaining to them that seeing as they have not stayed in the property, it doesn't mean that we all can assume that they don't know the condition of the property, because tenants sometimes does either themselves give information on certain defects or complaints, like we all know, or they give the information through via the rental agent. So from a practical point of view, your seller is going to sign the document, disclose as far as he can, and then once again indicate that the seller did not stay in the property due to the fact that it was tenanted. The purchaser had the opportunity and did familiarize himself fully in that regard. And once again, the seller gets indemnified as well as the estate agency. I do want to just add a bit of fine print to that, if you don't mind. And that is that you as the property practitioner do not have the duty to play FBI agent. So you do not have to go and open up unnecessary cans of worms. Do your part and make sure that the seller understands what is required of him, and educate your seller to ask the right questions with regards to the rental agents, etc., etc. Because what sometimes happens is you might have a rental agent in your own office where certain defects was disclosed, but the rental agent and the selling agent do not talk to each other. They're not communicating. Not on purpose, it happens accidentally because life happens. So when there's a rental property involved and your own office is dealing with that rental property, just make sure that something wasn't disclosed to your office.
Makes absolute sense.
And when there's a rental property where another office is dealing with it, I don't think it's your duty as the agent to go and knock on the door of the other agency and go and get all that gory details. Ask and make it the responsibility of your seller to get all that information. And where you can, make sure that it's done in writing.
Makes perfect sense.
Can I just add something there, if I may? That special clause that you mentioned also has got a word that the purchaser understands the implications of such non-disclosure. And what are these actual implications? It is a risk for this buyer to purchase a property without viewing it. And there I like to refer the real estate agents, the professionals out there, to subsection 5 that says nothing stops the purchaser from obtaining his own professional inspection done. And if I can give you some advice, perhaps in a scenario like that, I will get some sort of writing saying to the purchaser, we just want to bring it under your attention, Mr. Buyer, like in the special conditions, that you fully understand the implications of the seller not being able to comment on the condition, and that nothing stops or prohibits you to obtain a professional,
especially in such a situation. And that buyer beware, make yourself aware of
absolutely
of it, and do whatever you feel is necessary to safeguard your interests. Then another question I have is, the mandatory disclosure form is obviously in practice, we deal with a lot of second-hand properties, and it makes sense there. But we also get a lot of backlash from sellers that are selling, for example, vacant land, where they say that the certain property practitioner is not requiring this form when listing it. And, should our property practitioners at Meridian Realty want to list that vacant land, that, they're going to have to do it without the disclosure form. And also, another situation is, for example, where you're dealing with an off-plan development where the property is not yet built. So I would just like to get some clarity, Louis, on does this apply to all types of properties? How do
So again, putting your legal hats on and your legal glasses, we've briefly had this discussion in your beautiful boardroom and your beautiful offices earlier this morning. And just before I entered your office, I got a phone call or a voice note from an estate agent asking me the question, is it necessary when it comes to vacant land, farm property, to do a condition report on it? And then I legally said, with my legal glasses on, I referred him to, it's not about the property. It's about, if you read section 67(1) carefully, it says you cannot sell a property or without you obtaining a mandate, irrespective of the property. So before you can take a mandate, ongeag of it nou vacant land is, or it was a single residential, whatever land it is, for you to be able to sell that property, you need to obtain a mandate, and that mandate has to be accompanied with the property condition report, signed, property filled in and attached. So, yeah, in short, for vacant land, you need it.
Okay.
Antonie, could I maybe add on that? And Louis touched on it earlier. So we were talking about latent and patent defects. And I think that is where the problem comes in on vacant property, is we are so focused on houses and buildings and roofs leaking and all of those things that latent defects can be all types of defects. To make examples and just to put this in a more practical light is, I quite some time ago, and how correct this information is I don't know, but rumor had it that there was a big road that they were thinking of doing here in the Stellenbosch area. So if there was vacant land around that road, being thinking of or considering in the process of putting it up, that could affect the decision of the purchaser buying that property.
Absolutely.
And it could also be the type of land. It could also be that water seeps up on the property. So there's servitudes, encroachments. There's all types of other latent defects that could be applicable to that vacant piece of land. So it's not only about the physical property and a leaking roof that we're so used to dealing with.
Absolutely. Makes perfect sense. So the property practitioners out there just need to get into the habit of, absolutely insisting on this form before they market any form of property. I think that's clear. That's what the law states. Then, can you outline the legal consequences for sellers that misrepresent information on the disclosure form? So they are aware of a defect and they say, no, the defect does not exist.
Absolutely. So we've mentioned this word a couple of times, educating your client.
Yeah.
And you educate your client. That's why I mentioned those two news flashes of ours that pertaining to the food sweat laws. Educating them, what are the consequences if you do not disclose properly? What could happen? Can you cancel the transaction on a later stage, depending on wherever you are in the transfer process? Yes. So I don't want to say you have to speak fear into your seller, but educate them of the consequences of not disclosing and what could happen. And yes, if you do not disclose a latent defect and the new owner can prove that it was a latent defect, it wasn't disclosed, And most importantly, the third leg is that he fraudulently withheld to disclose valuable information with the intention to defraud. Boom! You can blow that deal out of the water. So you have to educate your clients of the consequences of not disclosing properly. And that's, again, just by explaining them the dynamics of what is latent and what is patent and what is footnotes.
Makes perfect sense. Then another question I have for you is, does the condition report impact the enforceability of an offer to purchase? So as conveyances, for example, let's say there's a deal that lands on your table and the mandatory disclosure form is not part and parcel of the agreement of sale. Can you still register?
Okay, well, my dad used to teach me one thing. He had a saying. He said, elke ou sien sy vrou op sy eie manier. Okay? So if I can take us as legal practitioners at DVH, first of all, I just must bring it under your attention that we're not regulated by the PPRA. So in terms of that, we do not have, if it's not part of your offer to purchase stating that there has to be attached here to a mandatory disclosure form, if that's not in the OTP, then we can go ahead. But in our practice, we teach our paralegals, if it's not attached, we immediately inform the real estate agent and we bring it under their attention. Luister hier, so jy moet 'n plan maak. You're going to take action and add it as soon as possible. And then we explain to them the consequences of not obtaining that. So from a practical point of view, we won't necessarily affect transfer after we've educated the real estate agent and say, listen, okay, attach it for us, get it, and then we can proceed. But from a legal point of view, we are not governed by the PPRA, and I've seen many attorneys, and I had many questions from many estate agents that confronted some attorneys, why did you proceed with registration? And then their answer is, we're not governed by the PPRA.
So in practice, it can happen.
It can happen.
And then there could be very dire consequences.
Absolutely, and it all boils down to the real estate agent. Why wasn't it attached?
Absolutely. Can a sale be challenged or cancelled if a material defect is discovered after the sale has been concluded but before it registers?
Antonie, that depends on what attorney you use. So if you've got a clued up attorney, anything is possible, especially if it's a material term that's essential to the offer to purchase. I've seen many of these things, but we normally try and settle it. But yes, that's a short answer.
Okay.
I'll make a practical example once again. So sometimes what happens is you might have purchasers looking at a property for a very specific reason. I need a property, I've got a young child who's got a medical issue, and I specifically cannot buy a property where there's any water involved. So I'm not talking about a swimming pool here, I'm talking about damp, I'm talking about roofs leaving moist, etc., etc., etc. And if that is one of the crucial reasons for purchasing that property, and they then prior to registration finds out, I would highly doubt that they'll be able to not get out of that transaction, especially if they can prove that they've mentioned it to that real estate practitioner more than once, maybe even in writing, etc., etc. And if you start going into examples, I'll be able to mention many. There's even sometimes situations where people want to buy in a specific area because in their opinion, it's a very quiet, tranquil area, and they specifically buy in that area for that, only to figure out that there might be a municipal pumping system close by, which was obviously not going to help them in that regard, and that could be a reason for them to want to get out of the deal. But once again, they at that point obviously had to inform the agent the reason why they were looking for property was specifically for those reasons.
Okay. All right, that makes sense.
While you're thinking on your next question, Antonie, before I forget, and we mentioned that earlier today, for heaven's sake, ladies and gentlemen, do not complete the mandatory disclosure form on behalf of your seller. And this is a true story that happened in Gansbaai. The seller was situated in Pretoria, but there were tenants in the property, and the eager, energetic real estate professional offered these services to the seller, said, don't worry. In terms of Section 67, we needed a completed and signed a property condition report, but don't worry, Mr. Seller, will you be happy if I do that inspection on your behalf? And obviously the seller, without being informed and the implications of that, he said, not a problem, you go ahead and fill in that form. And that is what this estate agent did. I mean, like we all estate agent will really go out of our way to please our clients. And this is exactly what this estate agent did, completed it. But they in one room, there were boxes still that needed to be removed. And eventually when the purchasers moved in, and with the boxes being removed, the purchasers discovered black mold. And we know purchasers, when they discover one problem, one thing leads to another. And obviously they got an expert opinion in and said, listen, you can't live in this property. So it all boiled down to the seller being very upset and frustrated with the real estate agent that actually just only wanted to help him.
Yeah.
And the purchaser saw this agent as a liar, said, you deliberately lied to us about this black mold. And that ended up in a terrible scenario, whereas the agent only tried to help. So please, if I can just categorically state it to all your real estate professionals, never fill it in on behalf of a seller.
Thank you. Well, there you've got it from the man himself. So on this point, what should property practitioners do if they discover defects in the property that is not disclosed on the form that was provided by the seller? You know, in practice, this happens from time to time. You do viewings with clients. Maybe the client sees something or you see something as a property practitioner and you realize, but there's a defect and this was not disclosed on the form.
So just recently this week, I had a scenario where the estate agent asked me, listen, Louis, I've followed ticked all the boxes in terms of Section 67 and regulations. I've got my property condition report filled in and it's all signed by the seller. And as I went through the property condition report, as I was taking clients through this property, I discovered other defects that was not disclosed. So, and I asked the agent, so what did you do? So she said, but she confronted the seller about these defects and informed him about the implications of not disclosing everything. And the seller said, well, go for it. We have to disclose it. And the estate agent disclosed that in the property condition report on the instruction of the seller and on the advice from the real estate agent. So yes, you have to disclose it. If you're aware of any defects as a real estate agent, disclose it.
I think another good practice would be, sometimes property is in the market for a very long time. So you might have received that condition report and then only a year later you get an offer to purchase. Also good practice to just revisit the seller at that juncture prior to signing it, to just find out, is there any new defects that might have...
No, you're 100% right, Antonie, but I see your property condition report quite well. In your property condition report, it will state that from date of signature, those were that was the condition of the property. But best practice, as you mentioned, is even if it's 2 months or 3 months or 2 weeks after completion, I will still advise a real estate professional to ask your seller, did anything change in this 2 weeks time that's lapsed? Oh, yes. Now that you've mentioned it, my swimming pool pump stopped working. Okay, then we disclose it. So best practice, absolutely right, Antonie.
So we've had instances where the transaction was already in our office. And I had a call from a estate agent, not once, many a times. And they would say, oh dear, I visited the property again with the purchaser and the neighbor quickly popped by and informed me of X, Y, and Z.
That's good.
Or I was visiting the property, doing maybe a COEC inspection, opening it up, etc., and then the agent discovered certain defects that they were not aware of previously. Whether they discussed it there and then with the seller or not, it is still the duty of the property practitioner to then disclose it.
Absolutely.
And in practice, how would they do it? Seeing as the transaction has already started, is to make sure that it's done in writing, and obviously also inform the transferring attorneys as an additional protection to make sure that everyone is informed about this additional information.
Okay. This has now been in practice from, when was it, about 2020?
Yeah, 20.
That it became enforceable,
2021.
Are there any recent court cases or legal proceedings involving disputes over this mandatory disclosure form? Do we have any case law to go on yet?
Not yet, because we are, as I'm standing here, waiting for a high court date for a case like this. And if you may allow me to briefly discuss that, what happened is I'll be very quick on that. It was a property that was sold about 2 years ago, and the purchaser obviously moved in, and with being living in the Western Cape with all the rains and stuff, we all have leaking roofs, and this one had excessive leaks in his roof, this owner, and he got in an expert structural engineer that went up into the roof and just printed a file this big of all the defects that could actually prove that the seller at that stage 2 years ago knew about, couldn't have not known about these defects. Okay, so what this new owner did is he issued summons against the seller, the previous owner. But in the meantime, this seller was sequestrated. So who is the best next person to gun?
The property practitioner.
The property practitioner. And this is exactly what they did. So they went to a very clever attorney and on technical points nailed, or is trying to nail, this property practitioner. This is why I say you as the principal and the broker owner, in the end, you are exposed, and your agents expose you as Antonie Goosen. So that's why we're having this discussion, so that you don't get summons in the end. So basically what happened is, in this transaction, the property was sold. The property condition report was not attached. The property condition report was not signed by the purchaser. And it also was not fully completed. And fourthly, they used a different format.
Everything that could
go wrong in section 67(1), they didn't do right. And in terms of the technical points that the estate agent didn't do, they are now issuing summons for 600,000. They initially sent out a letter of demand of 300,000 rand. But as we mentioned earlier, if it's not attached, signed, or fully completed, the property is sold as if there were no defects at all. So this is exactly what this clever attorney advised. Okay, so you don't want to pay, you don't want to negotiate. Now we're going to go for the full Monty. And they listed all the defects, and then they summons them for double the amount. 600,000 rand. So this is where we're at. We've got expert opinions on this, and we're waiting for a court date. So I'll give you I think with our courts, it's going to take about 5 years for a date. So can you just imagine putting a principal under that much stress for 5 years?
Not the place where you want to be.
Absolutely.
Or the property practitioner, for that matter.
Yeah.
So on that note, what advice do the two of you have for property practitioners to protect themselves from liability that originates or is related to property defects?
Tanja?
In short, educate. I think the words that we can also add to that is maybe manage our clients' expectations, so that they, with the education, they are fully aware of what the consequences will be. So if the property practitioner sticks to that specific section 67 and all the subsections to it that Louis very clearly mentioned earlier, there shouldn't be any issues. I do not think that it's the duty of a real estate agent to play FBI agent and go and look for and find stuff, but make sure that you educate your sellers and make sure that you ask the correct questions and prove that you've got the correct answers on that.
And I agree with you, it's not their responsibility to play FBI agents, but also be aware of what's happening around you. When you view the property, etc., point out what you can. Go in with open eyes.
I think another challenge is that we as property professionals and property practitioners face in in our industry is if you approach a seller and saying, listen, I cannot sell your property if I do not get a fully completed and signed mandatory disclosure form. And unfortunately, this is the industry we're in, because many agents out there don't ask for it. So that puts the Meridian agent on the spot immediately and say, listen, but why are you asking for a mandatory disclosure form? All the other agents that I dealt with, no one asked for that. And this comes in what Tanja mentioned is about educating our client. But sir, you know what? May I quote section 60, 67, 1, 2, 3, and 4, and 5. I am your best agent. I am going to sell your property, but please, you have to cooperate. Yeah. And we have to do that to protect your interest. And ladies and gentlemen, Antonie, if all else fails, we've got on our DVH app, we've got a certain section where it says forms. Then you tell your seller, Mr. Seller, I know you're not in the position right now or in the mood to complete this form for me, but what I'm going to do is I'm going to send this disclosure form for you, send it via my phone to your phone, and what your client will receive there is an exact copy or print format as prescribed by the PPRA, the Property Condition Report, which he can take on his phone, disclose everything, tick all the boxes, sign it with his finger, and WhatsApp it back. And at least, ladies and gentlemen, then you've got your signed property condition report. And I know what you're going to ask me now, but it's not signed in wet ink.
Yeah.
And the Act also clearly states that this form is an integral part of, that integral. So that basically implies that it has to be signed with wet ink. No. I'm of the opinion, I think my colleague here will agree, that is a documentation obtained prior to concluding the deal, which is not alienation of land.
Yeah.
That has to be signed in wet ink. Obviously, I won't advise for every transaction now to all of a sudden send it electronically.
And have them initial it at the time of taking the offer.
Exactly.
As well, just as a double.
Just as a double.
But I agree with your take on it. Okay, so now I want to talk about one question on the form itself, which, in my personal opinion, can be a bit confusing. So I'm going to ask you guys on the podcast to just put up the form so that we can discuss the relevant section. But in the form itself, there's a section under the provision of additional information that reads as follows, just so that the viewers out there understand. It says the owner represents that to the best of his or her knowledge, the responses to the statement in respect of the property contained herein have been accurately noted as yes, no, or not applicable. So those are your three options. Should the owner have responded to any of the statements with a yes, the owner shall be obliged to provide in the additional information area of this form a full explanation as to the response of the statement concerned. Now, then you have all these statements, but almost all of them, if you answer yes, you are in fact declaring a defect. And that's why this section also then says that if you said yes, you must elaborate on it. But there's one question that reads as follows. And there's, for me, in practice, a lot of confusion about this. It says, I am aware that any additions or improvements made to or any erections made on the property have been done or were made only after the required consents, permissions, and permits to do so were properly obtained. So in my opinion, if you say yes there, you are in fact saying that all improvements or erections on the property have been done with the required consents being in place. So you're not declaring a defect, you're actually stating that something is as it should be. Your opinion on that?
So, Antonie, I think the question wasn't in the right format or worded correctly. I think there should have been two questions. Number one, were there any alterations done, yes or no? And were they done according to plan or local council's provisions? So if you combine that question, there's a sort of a statement in it as well. But I'm 100% with you that the answer there would be yes. But then I will still, in that, obviously, where I elaborate on that, I put on record that all the alterations that I've done on this property has been done according to the laws of local government or local the local authority, and that if all my plans are approved. So the answer to that is yes, but also you can elaborate on that.
Okay. We are getting towards the end of the session. It's been incredibly insightful. I've got one last question for you. What single piece of advice would you give to property practitioners about working with the mandatory disclosure form? To wrap it all up.
Guys, it's unfortunately it's law. I think the intention of the legislator was not to gun the real estate, for lack of a better word, the real estate agent, but it unfortunately opens, in terms of this legislation, opens everything up for us to be implicated in a legal action. Like I mentioned earlier, on the formalities, the seller and the buyer can hold you liable if you do not comply. So my piece of advice to all the real estate agents out there is, please read through Section 67, and it basically comes down to get the freaking mandatory disclosure form ASAP, as soon as possible at mandate stage. Make sure that your seller understands the implications of what he is writing there, and that brings us what I mentioned in the beginning, understanding what is foot stewards, what is latent, what is patent. Attach it, send it to your prospective buyer for him to go through it, and when you conclude the offer to purchase, get it signed by all relevant parties, which you rightfully stated right in the beginning. I need the real estate agent's signature as well. Only those three things, then you shabalala.
You agree, Tanja?
I absolutely agree. Once again, education. Not only just educating your sellers, but making sure that you fully understand everything. And I think if you fully understand everything, it makes you and gives you that extra edge in being confident in bringing over the message and the detail to all of this. And then managing the expectations of your clients going forward. So educate, educate, educate.
Louis, Tanja, it's been a pleasure. Thank you so much for sharing all your knowledge. We really appreciate it. And from our side, that's over and out for today.
Thank you, everyone.